part of the experiment, you actually need to take your mobile phones and open the questionnaire on your mobile phone. And you do that either by scanning the QR code. That's the best way to do it. So you all have the QR codes on the little cards. Those not really
Recording in progress.
into QR codes can also type in the link there to the web browser, but I advise do the QR code instead. So if you already have that open, cool. Then there is a small arrow you can see circled that's used for going forward in the questionnaire. And please answer the first question, which is basically indicating which team you are, whether you are blue team or the red team. Cool. And now, if you've done so, you probably noticed that the questionnaire rerouted you to this screen full of text. Now we will read it. You can read it by yourself or just listen to me because I go through it as well, so it's your choice. Now it is about a workplace situation, and your task actually is to imagine that you are the main character of this story. So you are Peter, and you work at the procurement department in a big public company. And one day you are sent to a business trip, and you receive keys from the brand new car. You are happy, you are driving a new car, but soon you realize that actually only recently the cars have been replaced. That's why after returning from the business trip you decide to investigate this. And what you find out is that actually cars are being purchased at a much higher price, a classic one, and even cars in excellent conditions are being replaced. The same company always wins the contract, even if it does not, the competition is repeated, so it does. The one day, even you accidentally find yourself on the copy of an email where a responsible employee is actually giving instruction to buy 5 new cars from the same supplier. Yeah, and now, a blue team, please raise your hands, everybody. Who is the blue team? Okay, cool. So red team will wait for further instruction, and the blue team have task or job to do. And the job is to answer the question, how likely are you actually to report this illegal activity? And now remember, you are not the person sitting here in Riga on the whistleblowing conference, you are Peter, yes, a person from the procurement department. So how likely are you to report this on the scale from 0 to 10? 0 means definitely not, you are not going to that. To 10, definitely would report it, and you can choose the channel, of course. It doesn't matter whether to go internally or to go to a regulator or the prosecution. It's really up to you. The question is only if you are willing to report it on this scale from 0 to 10. So probably you will have to scroll the screen to the end of the scale. So you have a few seconds to do it. And for the red team, probably those who are the red team already noticed that if they went through the next slide, they realized that there is more text coming and we have more information for them. So you are still Peter, the red team, and on the same day you received that incriminating email. You went through a whistleblowing training session. On that training session, you learn that individuals who report threats to public interest are entitled to protection, that there is a whistleblowing protection office that offers assistance, safeguards, provide information, legal advice, can file reports on behalf of whistleblowers, and also have to measures that if the protected status is granted, whistleblower cannot be fired without the office consent, as well as the office may suspend the dismissal if it is related to the report. And in addition, the Whistleblower Protection Office allows for anonymous reporting through a secure web form. And as well, your institution actually adopted this similar secure web form, so you can also report completely anonymously at your employer. Now, the red team has the same task to answer whether they would actually report this illegal activity. So, how likely are you to do that on the same scale? From 0, definitely not, to 10, definitely yes. I give a few more minutes so I can load actually the real-time voting data here on my mobile phone. Okay, red team, are you ready? I hope you are with answering the question. So what I can see we have, okay, I need this. We have 22 people for blue team answering the questionnaire, and we have only 12 people answering for the red team. And if I look at the actually average answer or mean answer from that scale 0 to 10, I can see the average score for the blue team is 6.1, and for the red team is 6.4, so it's slightly higher. And if we take this as experiment and the groups would be like same and the conditions will be same, we can attribute this slight shift towards the intervention we made. And the intervention actually was that we provide more information to the red team about the protection and about the possibility to report anonymously. So we can attribute to these supportive tools. So you can imagine we did similar experiment, but much bigger for what we wanted to reveal. In our experiment, actually, we used the same fraud scenario for respondents to read. And in addition, we had 4 groups where we used 4 different treatments. The first group only read about the whistleblower protection. That was the group legislative protection. The second group read about the whistleblower protection, plus we gave them information about possibility to report anonymously. So like the red team today here. The third and fourth group also read about the whistleblower protection, but the extra information was not possibility to report anonymously, but instead they read about financial compensation of the whistleblower, and the fourth group read instead of that about possibility of getting reward. So that was the 4 interventions we tested for increasing the willingness to state to report. And we did this test actually on public sector employees. We almost received 1,000 questionnaires filled in. We divided all these people into 5 groups that were the same based on gender, region, municipality, size, and education. So the groups were the same. And I'm talking about 5 groups because we also had the group number 0 or the control group, which actually didn't get any information. They read only about the fraud scenario and then answered all the rest of the questions. And how did they answer it? You can see the results on the screen. The first, the control group, we can see the results on the scale from 0 to 10 was 6.6. So if we say the 5 is somewhere in the middle between the 0 and 10, then the control group was slightly leaning towards stating willingness to report the fraud, the procurement fraud. When we see the result of the group that actually read about the protection of whistleblowers, we can see the average score of their answers is 6.3, which is more or less the same like the control group. Yes. So that's not what we hoped for, actually. And we can see there is no added impact over the control group in actually increasing the stated willingness to report the fraud. Why is that? Our hypothesis is that actually it is very hard to talk about the whistleblower protection to people without acknowledging them the very negative consequences of blowing the whistle. So that means that if we are hoping that we will just talk about the whistleblower protection and people will be motivated to blow the whistle, probably is not enough, because we draw attention to what might happen, the negative side of whistleblowing. In case of the second group, the group that actually read about the protection and in addition read also about the anonymous reporting option, we can see the average answer was 7. And this is slightly higher than the rest. Actually, to be concrete, it is 6.2 points higher in comparison to respondents that didn't read about the possibility to report anonymously. And it is statistically significant increase, even though it's very slight. So we can say actually that possibility to report anonymously is increasing willingness of people to report. Controversially, the third and fourth group, both of them had some financial incentive as extra information with the whistleblower protection, and both of them, the results are 6.4, and there is no significant effect in increasing the willingness to report. Why is that? We will discuss. First, we think that actually the anonymity really removes the top barrier that can be there for whistleblowing, which is fear of retaliation. We could see it from this survey. We also could see it actually from other public opinion poll, which we do every year. And besides another question, we ask every time what people think might be motivating for other people to actually report some fraud. And every year we actually get the result that more than half or more than 50% of people always choose the possibility to report anonymously as the motivating tool for other people to involve in blowing the whistle. No, but I wanted also to talk about Latvia because we are here in Riga. And luckily we have special Eurobarometer for corruption, and there is actually reporting corruption question. And this question is asking people to pick 3 possible reasons why people do not report corruption. Of course, there are some differences between reporting corruption and reporting other misconduct, but still we can see that I chose top 5 for Latvians that they picked, and we can see that among the top 5, 2 of them are connected to kind of consequences. The number 3 is there is no protection from retaliation, so that's classic fear of retaliation, and number 5 is fear from other negative consequences that might come from blowing the whistle. Actually, the Latvians are not so different than the Slovaks, so I think it is more or less very similar, the answers. So we believe that the anonymity itself might help people to actually get some psychological safety in blowing the whistle and kind of sense of control over this act, because it doesn't matter or it doesn't mean for them they need to be a superhero, so they can still be ordinary employees, speak up, and don't actually get into the spotlight. So that's probably how the anonymity works for whistleblowers. Yes, and why the financial incentives might be tricky. In case the third group, so they read about the whistleblowing protection, And in addition, we gave them information how they can be compensated if the legal protection somehow failed and they get dismissed. And this, we think, draw the attention even more in them to the possibility of job loss. So we really believe that that led to additional doubts about really reporting the fraud. And of course, the word in itself, like compensation, really means something that you first have to lose something and then you get compensated. Then it means when a person is thinking about, like, is not in the situation, is we are still about some stated willingness to report. So in this pre-whistleblowing, some hypothetical situation, it makes person to think twice about whether they are going to do that or not. In case of the reward, there are several academic research on this topic, and they say that the financial rewards can reduce the internal motivation for reporting and can actually put person to a state that he starts to evaluate the profit versus the cost, what I can get in what I can lose scenario. And in our case, we actually describe the reward very vaguely. We just said it will be 30% of the fine given by the regulator, so we didn't use any concrete sum. And we believe that this might be the thing that wasn't that appealing for them in that situation, like is it worth some 30% of some, I don't know, fine what is going to be. So that's why we think that further research is needed to actually test some other sums, maybe concrete sums or other composition of the rewards. Besides this, the stated willingness to report, we also looked at factors that might be affecting the willingness to report. We looked at individual factors, situational factors, and what we learned was that the gravity of situation, or perceived gravity of situation, has the strongest effect among all the factors we looked at in positively affecting the willingness to report, which means that people who actually perceive that hypothetical fraud scenario as harmful to the organization was more willing to report than those people who perceived that fraud as not that harmful or not that important for the organization. Other factors that were statistically significant with their effect on stated willingness to report was support by the institution, prior knowledge of whistleblowing, prior knowledge meaning before they were part of our experiment, and trust in stopping the misconduct. On other side, we see factors that discourages people from stating the willingness to report, which are two factors, risk aversion. So person that is more averse towards risk is, of course, less likely to state the willingness to report. And as well, the degree of individualism, which means people who tend to be more individualistic as well tend to less likely state they are going to report the fraud. So this was the most significant factors affecting the stating willingness to report. And what we learned, our findings are based actually on the stated willingness to report and other self-assessed characteristics. And of course, there is a long way from kind of this experiment and stated willingness to report to actually reporting it, because other factors came into play into that until the moment someone blew the whistle. But anyway, it still can give us some insight about how supportive measures might work for the whistleblowers in their mind, and how they can be motivating people to blow the whistle. And what we learned that anonymity works best, and the recommendation would be that if you have anonymous channel, we would recommend really promote it, because that's what we find out to have significant effect on motivating people to actually report the misconduct that they see. In case of financial incentives, here we recommend really to carefully design them and maybe also test them, because the effect might be unclear if we are looking on the motivating side of whistleblowing. And whistleblower protection is definitely necessary, but talking only about that probably won't really give us in giving or having higher numbers of people that are reporting. But what works is trust and communication, what we've seen from the factors that are affecting the willingness to report. So if people actually see the results of investigation, if they actually can read positive whistleblowing stories, then it can actually increase their trust in stopping the fraud, which means then they are more willing to report when they see misconduct. Also, what works is when people are aware of the harmfulness of the misconduct. If they perceive that concrete wrongdoing as harmful, then they are more likely to report it. That's what we learned. And this is the last slide from me. It is a thank you slide, because we actually did this report as a collective of authors, and we collaborated with analysts from Ministry of Finance. So a big thank you to them, because they did actually all the math behind this.
I think thanks you very much for your presentation. And are there any questions? Yeah.
So thank you, Ludmila, for a very interesting experiment and presentation. How do you think, if we provide for anonymous reporting in our legislation, and then some retaliation happens against this person, and we have to protect this person, how do we do it? Because we don't know the name and the last name. We don't know which person was that. Maybe you have some idea.
I think once a person gets retaliated, it's quite clear that he's known that it was him who blew the whistle. So you know already. So if a person is retaliated, even if he blew the whistle anonymously, so he must have been revealed, otherwise he wouldn't be retaliated. That is the person. Yeah, he has to come forward and tell it that it was me, and I had, of course, some proof that it was him.
Any other questions?
Yes, in addition to previous question, yes, there is what is the difference between, so in Latvia you can report anonymously about any cases. For instance, in CNAB, Corruption Prevention Bureau, we receive a lot of reports where people report anonymously, and we proceed them as we should do according to our competence. So I think maybe there is also the problem. People do not see the difference between whistleblowing and reporting anonymously. And yes, the problem is, so in any case, sooner or later, this in your case in Slovakia, the person who reported anonymously became known. So just he needs the protection. We should discover him, or how it works. And what is the difference between reporting anonymously without being whistleblower and anonymous reporting through the whistleblowing system?
To be honest, what we looked in this our test was which supportive measures might have an impact on, like a motivating impact on people. So the practicalities, yes, they are there. In our office, we usually get like 30% of submissions are anonymous. Sometimes happens that person first come anonymously if he or she stays in touch. Sometimes they reveal themselves in the process because they start to trust our lawyers and they decide they want to be known, to deal directly. Sometimes it doesn't, depends. So sometimes we have many times we have problem that people report anonymously. We need to get back to them, and they are not expiring the emails. Yes, this happens.
I think we can tell you thanks for your presentation and thanks for stressing these important things. What we need to also take into account when doing some improvements, maybe in Latvian regulation, just what you trust as are the values. Like you was mentioned that trust and communication is one which is very, very important. Also this anonymity. And thanks you for showing this, and thanks you also for sharing your practice and your presentation, which really looked like good experiment for us to understand what are the main principles, what we need to take into account, what are important for these whistleblowers who are doing a good job.
Yeah, I actually forgot to tell you that at the end of the questionnaire there is a link for the report which is in English. So those who want to read it, please do. There are far more information that I gave you today.
Thank you very much. And we are going into whistleblowing much deeper and deeper. And now I will invite to Evita Goša, who is head of the Shadow Economic Combat Working Group for the Foreign Investors Council in Latvia. And also I'm proud to tell that Evita is also the chairperson of Transparency International Latvia Council. So, and she also represents the private sector. So today you will have a moderator who comes also from the private sector. So maybe you will have a bit different discussions. So I am giving floor to Evita and her speakers now.
Thank you very much. Indeed, first of all, I wanted to add a little bit of credibility to my status, just being part of the or member of business and also Foreign Investors Council. But Agnia already explained my role also in Transparency International. Indeed, so it is hard to believe actually that we have approached the last session of today's conference. So most of your attention should be here. And this time we will focus specifically on whistleblowing in defense sector, so how to reconcile two kind of ethical dilemma issues, confidentiality on one side and some sort of wrongdoings on the other side. So we will have three speakers here. I would actually want to invite them immediately here so that I can also introduce you to them. So please come over, those who are here. And we will have one panelist also remotely. So just please come over and take whichever seat seems to be most comfortable to you. So all of them are here. I would first of all like to introduce to you the closest speaker, not only to me now personally, but also geographically. So the speaker from Lithuania and representing Prosecutor's Office, General Prosecutor's Office, Deputy Chief Prosecutor, Internal Investigations Division, right? Monika Kalinauskiene. Welcome. I would also, Did I say something wrong? No. I'm not cut off. We also have Zuzana Dlugoshova. I hope I really pronounced that name correctly. I'm really worried. I already expressed that to some of the colleagues here that I pronounced names correctly. President of the Office for the Protection of Whistleblowers in Slovakia. Welcome. And we also have, again, a moment of truth. Tania Segovia Fernandez, expert and lawyer in whistleblower protection, Valencia Anti-Corruption Agency, Spain. And remotely, we also have Crystal Mercade, representative of the EU Whistleblower Directive team, Director General for Justice and Consumers from the European Commission. Welcome. We will mainly focus today on the European Union legal framework, focusing on Whistleblower Protection Directive, Defense and Security Procurement Directive, and limits or derogations based on Article 346 of the Treaty on the Functioning of the European Union. And in order to delve or dive into this significant topic, actually raising in importance nowadays, very unfortunately, but this is so. Therefore, I would like to give the floor for the introductory speech specifically to our remote speaker. Crystal, the floor is yours.
Good afternoon, everyone. I hope you can hear me well. It's a bit overwhelming seeing myself in 3 different screens through the presentation. I think it's the first time I see myself in so many perspectives. Thank you very much for inviting me to talk on this important topic of the directive. And just let me remark as well that this conference is very important for us, not only because it's part of one of the projects that we fund under our very small funding budget, but it's also for the fact that the agenda, I think, throughout the day touched upon a lot of very important topics as regards the proper transposition and implementation of the Whistleblower Directive. So I personally welcome very much this conference, and I hope that the attention, even though it's almost Friday afternoon, will still continue to discuss this topic relating to national security. While discussing with the organizers of this conference, we thought that it would be a good idea to start by framing what the Whistleblower Directive provides for in terms of relationship between the provisions of the directive and the topic of national security, including also confidential information. I had prepared a PowerPoint, but I'm afraid don't think that Zoom allows me to share the PowerPoint. So what I propose is that I will distribute it to the organizers, and if there is some interested participants, they can receive it after the conference. But I will be very succinct. So it is clear that the idea of the directive is to provide protection for those who aim to enforce the union law. So the idea is to provide for or ensure effective enforcement of EU law. Article 3 of the directive establishes the relationship between this objective and other, let's say, objective under EU and national law. One of which, of course, is the obligation, or let's say the prerogative of member states to ensure national security and classified information. That's provided in Article 3.2 and 3.3 of the directive. So the challenge here is to reconcile two, let's say, divergent objectives. On the one side, the fact that the directive encourages reporting information, be it sensitive or not sensitive, under the prescribed channels. And on the other side, the objective of the state to keep certain types of information under strict security. It is important to say that both Article 3.2 and 3.3 does not exclude from the scope of application both national security and confidential information. I allow myself to explain that I was part of the team drafting the directive, and the choice made of words was very deliberate, and it doesn't say shall not apply, but it says shall not affect. the responsibility of member states to ensure national security and classified information. Hence, the idea was not to give member states a blanket exception to the purpose of the directive, but rather to encourage them to have a balanced approach to both objectives, as I explained. On the one side, to ensure that the directive allows people to report breaches, even if the type of information is considered sensitive, and on the other side, to ensure that those type of information can be treated differently from, let's say, regular information, for example, on transport safety. This was ensured also in light of the principles of the Council of Europe recommendation of 2014, which is part of the basis of our directive. The principle number 5 explains that there is a need for balancing transparency with legitimate secrecy, and that there should not be an automatic exclusion of information just for the fact that they might fall under the notion of national security under national legislation. That principle also reflects the case law of the European Court of Human Rights. Another notion is why the directive chose the notion of national security, not public order, is because national security, and I think this is one of the topics that will be touched upon by the other speakers, is much more narrow than, for example, other notions of the EU law which relate to public order. So the idea was already to ensure that the notion of national security, or the notion of what type of information may be provided for different channels, for example, was much narrowly constructed than other type of, let's say, categories of information falling under national public order. For example, areas like data protection, health, and environmental safety would not be deemed to fall under the notion of national security. In practice, the balancing between the directive, so the material scope of the directive and the notion of national security only coincides in one topic, which is the defense procurement in the defense sector. So this is an instrument that was added in the annex, which the directive allows for people to report. I think nowadays this is an important sector that should fall under the material scope of the directive, and therefore it is clear that the notion of national security should be constructed in a way that does not derogate from the actual material scope of the directive. Same for classified information. Under the notion of classified information, which falls under Article 3.3 of the directive, there would be other categories, for example, like nuclear safety, or some other type of information which are sensitive without falling on national security. But the idea would be the same, that member states have to provide for an adequate balance between the two objectives. On the one side, to report those type of information, and on the other side, to protect the sensitivity of the information. How can member states do that? The directive is not prescriptive about it, but there has been already some member states who have ensured, for example, that those type of information can be reported through different reporting channels, be it both internally within the authority, for example, the Ministry of Defense, or externally through a specific competent authority, which is, for example, has received security clearance, for example. So there are some member states already who have provided this in order to ensure this balance between the sensitivity of the information and the fact that it should be possible to report about it. What about public disclosures? This is an area where there has been already case law of the European Court of Human Rights, where the European Court of Human Rights has said that there should not be, again, a blanket exception. So public disclosures on those areas should not be prohibited per se. There should be an ex ante authorization or independent authority who can have access to this type of information in order to ensure that there is a possibility, if the authority deems so relevant, to publicly disclose this information. Which type of authority? The court has pointed to, for example, judicial courts, ombudsmen, etc., who should have access to the information in order to decide whether the disclosure serves the public interest as defined under the jurisprudence of the European Court of Human Rights, or truly would endanger national security. So the idea under the directive is that a total prohibition of disclosures, reports or disclosures under the label of national security or confidential information do not ensure this adequate balance. And in a number of documents that the Commission has published, more recently the report on transposition of the directive that we published last year in July in 2024, it is crystal clear that the Commission said that those member states who have blanket exceptions under the title of national security or confidential information do not comply with the objectives of the directive by making that balance. What type of issues have we found? Not only blanket exceptions, but also some member states have exempted whole categories of personnel. So, for example, military personnel are not allowed to report about any issue, or police officers, etc. So those are clear objectives of the directive that should not be compromised by blanket exceptions or exemptions on the personnel. In conclusion, and just to set the tone of this discussion, the idea would be for member states to construct a system on the one side to protect their own interests and national security and confidentiality, and on the other side to protect the objectives of the directive, which is at the end ensuring the enforcement of the law, EU or national law, and protecting those who come across these breaches and report about it. Thank you very much, and I'm looking forward to discuss the subsequent points with the other speakers.
Thank you very much indeed. And now let's move on to member states. So we have Lithuania, Slovakia, and Spain. And for instance, in a defense procurement scenario, then which alleged breaches clearly would fall under whistleblowers protection directive? Then let's say with very practical examples. So how do we deal with what Crystal just described? So feel free. Mics are here.
Well, taking into account political situation nowadays, all countries have a lot of procurement going on in the military sector, and I think it is already a very important topic, and in the future it will be evolving, because lots of countries, not only our countries, are buying lots of things for their defense, building factories for making necessary things for our defense. And I'm sure we will have, and maybe we already have, people who know some facts about these procurement procedures, because it's not a secret that these contracts usually involve very huge amount of money, and also ammunition things can be bought from different countries and different suppliers, and we may find a lot of things behind that. So personally, I think that public procurement and all this in a defense sector is very important topic, and I had the pleasure evaluating Ukraine system, so I can tell that we can take a lot of good things from Ukraine, and they strive now to include all military personnel in a whistleblowers area is a great thing. So I think if not all the countries in Europe are now familiar with this type of whistleblowers, I'm sure we will be in the near future.
Yes, I would like to say that I feel in this panel as a practitioner that has almost no practical experience with that. With this, for a simple reason, because we are one of those countries that use the blanket provision in our law that basically excludes everything what is classified information from any kind of whistleblower protection, and also all members of intelligence service, for example, not the military personnel, but even the classified information might be especially in the defense area, an issue. And my perception for the time being, and of course I don't speak on behalf of all of the EU member states, Country Christel can give us more insight into how much is these blanket exceptions transposition used. But my perception is that the national security interest is often used as a general reason to avoid any kind of scrutiny of legality in the entire areas. For example, in Slovakia, there is an interesting trend that everything what needs to be done very quickly goes through the Ministry of Defense. So the Ministry of Defense start building hospitals more quicker than the regular state Ministry of Health. They start building schools because they go much more effective, because they don't apply as strict rules of public procurement, etc. And the general perception, this kind of discouraging and deterrent effect on people, is that anything what goes through that system is kind of behind the corporate wheel that shouldn't be spoken about. And this discouraging effect is the reason why we actually don't have any kind of regulation and any kind of awareness that in case there is a real corruption case or some wrongdoing in that system, goes undetected or goes not transparent. So people naturally avoid any kind of attempts to report. That's a big challenge, I think, for the whole region.
But I will immediately have a question, if I may. Then have you tried to somehow raise the discussion, the public debate about this, and what the perception is in the society? Because well, it, on the one hand, of course, I mean, this is a very important area at this point of time. But on the other hand, of course, we can't simply hope or expect somehow that everything's perfect in this industry. So yeah, what's the take on that?
Yes, even at the very, very beginning, when we started the Office of Whistleblower Protection, and we got familiar with the existing regulation under which we should operate, we actually pointed out to that aspect of not transposing directive correctly, but there was simply no political will into going to two sensitive issues, because we have many other exceptions in the law, not only concerning classified information and intelligence service officers, also other parts like bank secrecy, tax secrecy. Actually, the reasons why the directive was written, because of the money laundering and corrupt financial systems. This was simply too sensitive for any kind of existing political coalition to open that part of the provision. So simply we haven't succeeded yet. So maybe the moment will come still, we hope so, but yeah, there are many different problems on our plate, but that was, as a first attempt, that wasn't successful politically.
Thank you. What about the situation in Spain in this regard?
Okay, we have the same situation that Slovenia. We had an exception. Excuse me, Slovakia. I'm nervous. We don't provide protection in material of defense or military procurements, but we have to see what we can find behind of this. For example, in Spain, industrial and technological base is a strategical sector with significant economical impact. Somehow in 2022, the benefits of this industry was more than 12 billion of euros, and the employment more than 112,000 people. Then we can think a little bit about of this that we can discuss later if we think. With our exemption, we can, if we find, or I think in the country find some report about this material, we can go to the case law of the European Court of Justice that is quite clear in this point. Is the key, mainly the key, crucial to forcing the transparency in front of defense sector and military sector. For them, the basis we may take in account, we should take in account is that the exception of the 346 article of the treaty has been applied restrictively. And must to be justified why is one material that can harm or jeopardize the defense of one member state. Has to, as I said, has to be proportionally and necessary and proportional to base this exemption, and must be relevant to have a point in this material. What we can find in front of this, the doctrine sometimes is quite, how to explain, is quite reactive in front of this, because it can be a limitation of the competition of the normal rules of procurement. In the point of view of protection, whistleblower protection, must be excluded of the exemption, and then can be protected materials like, for example, the dual use military and arms. And we can find cases of, for example, the case C650 line 10 that was exactly explaining about it does not apply this exception in dual use of material of war. Okay, or civil.
Thank you very much. But then what about the situation in Lithuania in this regard? So do you also have some sort of blanket exemption, or?
No. Actually, I want to shift a bit from a different angle. The country can have an exemption. It can be clearly written that state secret fall under the scope of whistleblowers or are excluded, but we have to think what we will do if whistleblower comes to authority and blows a whistle on a secret information. So you cannot tell him that go out, it's out of the scope. When you have such a situation, you have to be ready. You have to have clear procedures. How will you work? Because usually those people, they are not revealing all the information. So you cannot tell from the first glimpse if it is a state secret, if it is a public procurement, if it is like classified information or no. I think that we as competent authorities, we have to be prepared. It doesn't matter if we have an exemption or not. And if I could switch to the procedures, I mean, my point of view on how can we be prepared. So Crystal mentioned that the directive allows different ways of reporting of this information because obviously this information is different from regular reports. And it was mentioned that these whistleblowers, they can report inside or they can report externally. And personally, I believe that usually these kind of whistleblowers, they tend to report externally. And here we come to the situation that we have to instruct whistleblowers how to do that and how to do it securely and to the right authority. And I think that probably practice, of course, will say how it will work, but there could be a core principles on how we could instruct these kind of whistleblowers. For example, that there should be data minimalization at the first step. They should not expose all the data at the first time. Of course, it would be very good if this reporting could come into stages. For example, whistleblower knows something, he calls to the authority for the information, or he meets personally with someone. Probably, to my mind, it would be like the best thing to meet personally without using any digital tools to report. And next thing is that not all the institutions, not all the channels can receive this classified information because they have to be cleared for security reasons. So people have to know where they can report this information, right? Not to every authority, not to every institution, because not every institution has the right to investigate this information. And the most important thing, I think, the first step would be that this kind of whistleblowers, they must have a right to signal that there is something bad happening without disclosing at the first stage the secret information. Just a signal that some procurement contract is not going right. And then they have to be directed to the right authority, which is capable of investigation and capable of saving confidentiality of this person.
So you really opened up, of course, the whole spectrum of the complexity of this issue, but you described it in a way how you think it should be, and the question is if this is the case in Lithuania, for instance, at this point of time. And then my next question would be, in those countries in which these blanket exceptions exist or exemptions, what to do there? Because if there is no system created, if there is no cooperation, collaboration among the involved institutions, and the potential whistleblower is pretty much alone, let's say, with his or her information and understanding of the situation, how to proceed?
Yes, thank you for that challenge, because I agree with Monica that we as legal practitioners, knowing the directive, knowing about the direct effect of the directive, if it's not transposed properly, that we should deal with the question with the real life situation, how to navigate whistleblowers. But I would very like to convey the message from this expert community, from this conference, that it is really, really important to change the laws, because even good thinking, normal expert, let's say an attorney, when a potential whistleblower comes for a legal advice and he or she reads the law, then the message would be, you will for sure face criminal investigation and criminal prosecution. It is totally excluded. Of course, we will fight for it if he or she is more or less oriented, but yes, the risk and discouraging effect is clear, and it is my belief that this is why we don't see across Europe much of these types of whistleblowing report, although potentially, and with the growing defense procurement, and not only because of the situation in Europe, but in general, these are millions of euros that flow through these industries, and where is money, there is wrongdoing or motivation for corrupt behavior. So it is really important that we don't have these blanket provisions in our laws, because even when someone comes to our office, if we then contemplate on the potential situation, of course we will navigate the person potentially, most probably, to the prosecution service that has the security clearance, and also try our best to consult the prosecution service ahead of time in order to avoid any negative consequences for potential whistleblowers, because I believe that even an ordinary prosecutors might take the case in a traditional way, that actually there is a problem and there'll be consequences when they reveal the classified information, for example. So yes, it is a challenge, and we must acknowledge and we must send an urgent message, and I hope the Commission will do the same towards those member states that took the shortcut in their national laws. And of course, I hope that we will come to the details of how we can serve under the circumstances potential whistleblowers. But yes, we might discourage them to the extent that we don't have them at all.
Thank you. Tanya.
I mean,
yeah, I will give the floor, Crystal, to you as well, because indeed, I think we touched upon something that where Commission could play a lot bigger role or more visible role.
Fast, and then we give the floor.
It's okay.
We have the same problem than Susanna. And what do you think about anonymity in this case? For example, but to make the report under the anonymity possibility, but for this is really important to ensure that the anonymity is really secure. For example, with the program networks like Tor, that we, for example, use in our institution, which hides the user's IP, and all. I mean, this situation could be one important situation, a possibility. Also, with a good system, which is giving, the institution and the anonymous person can intercambiate information the secure way, with a special code and with encryption information and dates. I think this is one possibility that that I sent to the rest. And what do you think about this?
No, this is the question to the audience already, but maybe before we give the floor to the audience, Crystal, indeed, could you elaborate a little bit more now that we see that there is an issue with these blanket exemptions? How many member states actually have them? How really large is this issue, and what the Commission is planning to do about it?
Thank you. I think we touched upon a lot of topics I would like to talk about, but the first and foremost is that I think touching upon, for example, public procurement on the area of defense. This is the precise example I mentioned, that the directive in its material scope already contains a directive, which is Directive 2009/91 on public procurement on defense. Why did we include this, even though that is a clear overlap with national security interests? Is because issues on those directives on public procurement not only per se have a problem on competition. If you dismiss the rules on procurement, that means that you award somebody over somebody else, even though the somebody else might be the one willing, but also could affect the financial interests of the EU. It should be EU money. So we have also legitimacy from the European Union to enforce the effective protection of EU money when such a EU money is used to buy military defense, military weapons, and other type of military equipment. But also in the future, there could be also issues of corruption, criminal liability as well on those. So there is a number of aspects that not only touch upon national security, but touches upon other areas that are part of the material scope of the directive. And hence, as I mentioned before, blanket exemptions would de facto derogate from the material scope of the directive by not allowing people to report on things that are reportable, let's put it in that verb, under the material scope of the directive, and should be reportable under the national laws. So as per the material scope, it is clear that there are parts on those blanket exceptions that directly contradict even the material scope of the directive. What to do on those cases? It's a very good question, and what the Commission has done so far. Some of the participants know, right? We are having bilateral dialogues on these things, on these issues with member states, in the hope that there is an article under the directive, which is also part of this conference, which is the review of the framework every 3 years. So every 3 years, the competent authorities, the national laws, should be reviewed in order to check the compatibility not only of the directive, but also the actual functioning of the national laws on whistleblower protection. So that is, on the national side, an opportunity every 3 years to feed in what should be a correct interpretation of the directive. On our side, not to take away the obligations of the Commission, of course, the ultimate weapon is to launch infringement proceedings on that purpose, if we consider and continue the dialogue with the member states on those issues, and we see that there is no other option, we ultimately launch infringement procedures against those member states. I cannot tell you how many have put the blanket exception because I don't have the numbers, but I can tell you that there is a large number of member states who have not correctly transposed that provision, either on national security or on confidential information. And ultimately, of course, there is a practicality as well on the competent authorities. I think Monica has hinted on it. I mean, if you have somebody, part of the military, coming to the competent authority, there should be some sort of treatment of this information, maybe referring them to people who have security clearance, private prosecutors, I don't know, other instances, as I said, maybe directly to the judges in a review of proceedings. But it has to be clear that the blanket exceptions are not only against the provisions of the directive, but also against the case law of the European Court of Human Rights. So there has been cases already of public prosecutors going on public disclosures, on intelligence services, going forward publicly. I'm not even saying to competent authorities, but publicly with information on considered as confidential or against the state nations, where the European Court of Human Rights has upheld the defendants, those who have been retaliated against, because in light of their right of freedom of expression. So I think there are two types of thresholds here, not only the directive vis-a-vis the directive and European law, but also vis-a-vis fundamental rights and the right of freedom of expression, how it is interpreted in the Court of Justice. So in practical terms, I would encourage in the meantime that the national law is not solved, to find for alternative solutions so that those people can report about it and can be protected. And ultimately, of course, it's the role of national courts to apply national law in light of their obligations, both at European and an international level.
Thank you very much. But then I think really the panelists have given you a flavor of the complexity of this area. And let's open really the interactive part of this panel, and we start in a totally non-traditional way, right? By asking the question to the audience first, not the opposite. So maybe very briefly, you could just repeat the question to the audience regarding the anonymity.
Oh, okay. What do you think with the possibility of use the anonymity and the anonymity channels with all the guarantees to report in this spatial material if you have the exemptions in your law?
I mean, I would say it's very tricky and it can be quite dangerous because, you know, anonymity only goes so far, and sometimes, you know, even with the better, if we think we take the right measures to keep ourselves anonymous, it's not always effective, you know, like sometimes there are only a few people who know about something, so then it's easy to deduce who they are. You might have talked to people before, like, you know, trying to understand how things are, so eventually if there is an investigation that will come out. And if, I mean, in that case, because we're talking about state secret, if the state is really, you know, trying to find out who that person is, they also have some means that are quite significant. So I would say anonymity doesn't replace proper channels and proper legal protection. And I think the idea of having special channels for this type of information is valid as long as they function and they offer the same kind of protection than others. So, yeah.
Would you like to reflect?
Yes, I would like to oppose it a little bit. I think it might be more complex. Not saying that this is bad or wrong, but I just can imagine a situation where you either anonymously report to the proper channel that has the security clearance even, so they actually are the competent body to deal with that, and they simply, like, securing the state secret and all the classified information, just go into the matter of the suspicion. Or another option that might happen in real life, that you anonymously report to, let's say, other authority that is not really authorized to learn that classified information, and then actually the machinery can start, and the risk can be that actually the law enforcement authorities can start investigating who actually breached the state secret or classified information. And in that sense, I would then actually develop further the potential scenario that, of course, if the person identity would be revealed, then again, the same should be applicable, and then we would actually weigh out the circumstances of the case, as some cases of the case law of the European Court of Human Rights, that you should then actually then evaluate what was the option for the whistleblower, whether he or she has had the other opportunity, how the system operates, whether it can be trusted, etc. And then, of course, the potential protection can come on the table, but depends on the situation. The higher risk is there, but it's not totally out of the question that you should then, maybe after 7 or 10 years, come to the conclusion that your rights were violated.
Tanya, additions or yeah, no, or Monica, would you like to also? Yeah, for sure. We will then again.
And as to the case law, my favorite is Bucur and Toma versus Romania from 2013. So if you would like to see some principles and thinking of the evaluation of the European Court of Human Rights, this is a very nice case scenario of the intelligence service officer who publicly actually held a press conference even on some illegal interceptions of civil society members, politicians, and other politicians.
Thank you. Yeah, so then we move on to questions or still continue on the...
I think it's the debate that's important here.
Okay, exactly.
Because it's all very well to sit there when you're not the whistleblower. And I've been somebody who's had the Official Secrets Act pointed at me and say, oh, let's find the right people, then let's decide who can represent them. This is not going to work. And we do work with and we do represent people who are looking for the right people to talk to, and we are very fortunate in having established credibility with the security services that we have our own inside track. Not everyone is lucky enough to develop those skills and those relationships. So if you are putting yourself in the position of the whistleblower, that you want them to come forward with information about, we're looking at over 4.5, nearly 5 billion that we know about of fraud, procurement fraud across the EU. You want people to come forward about this. We have to make it easier. And while I'm not suggesting that everything that's being done is wrong, if you don't make it simple, they're not going to come out. We have put forward into our proposals in the UK a clause that sort of circumnavigates the Official Secrets Act, which is about the public defence. And by doing that, you've got more chance of somebody coming forward. But my final point on this is, yet again, we're looking at the whistleblower rather than looking at the whistleblowing. And surely, as politicians, as policy experts, as budget holders, we need to know where that information is. We shouldn't really be giving too much of a hoot who it's coming from, because we're the ones who can check it.
Reflections on that?
Yes, correctly. I can really imagine a situation where we don't need to know who reported. We just need to know information. And we have all the tools to investigate if some contract was clear or no. So yes, it's true. But every situation is different. And yes, I completely agree that we have to step into whistleblower shoes. And we have to think out of, not from the side of the government, but from the side of a whistleblower. Yeah.
Within your office, if you have one central office,
yes, we do.
What we're proposing is we have a specialist in each sector. So if you have sectors specialists, you'll have security cleared people to whom those inquiries can be directed, because it's making it easy that actually is the route to intervening in fraud, corruption and other wrongdoing, isn't it? I'd love you guys to do it from the EU side, because then we might persuade our government that what we're talking about actually makes sense.
Yes, probably it's always better for a whistleblower if he has to come to one person and to speak like directly and not being like, transferred to another authority. And especially in this security sector, the less people know is the better. So yes, but that's why we were talking about having special communication protocols and special dedicated persons who can work with this information. But the most important thing is that whistleblowers, they have to know where to go. But we have to know how to proceed before directing them to us or to any other authority. We have to know what steps we will take, and we have to know it in advance, I think, before having these whistleblowers.
Thank you. You still want to reflect on that?
Yeah, just a very quick reflection that, the ideal case scenario would be that the state can actively communicate if it comes to the classified information, top secret, defense, procurement. This is the address. The problem is when you have the blanket information in the national law, then of course the official communication then is somehow controversial because other authorities would not be even willing to accept that position of receiving the whistleblower report. So that's why we really need to change the legislation. But despite, on my own behalf, I would say that if somebody shows up, even having this blanket provision, we would navigate and we would first contact the potential institution that can deal with classified information, communicate with them, and then send the person. That's how we would proceed. But the official communication to navigate just in case is somehow problematic for the moment.
Okay, exactly the same, but our aim is always to protect whistleblower and what they live when they report at the same moment, at the first moment. I mean, I'm with them directly. I'm working with them in the first line, and it's not that easy. We do everything we can do, even more, sometimes in the line, and it's our aim always protect them. And sometimes we have to say what they are going to find, but we are with them, next to them, and taking their hands always. Just today I was writing with one of them, just waiting there. I mean, we are not stopping, and for us, we put ourselves in their shoes, always.
Now that we are under time pressure a bit, we would like to take, I think, one more question and then close the session. Everyone's ready? You're ready for Friday evening? Yes? Okay, it's time then. So I would like to give us all a round of applause to all our panelists. And I will pass the floor to Agnia for final remarks.
Thanks, Evita. Also, thanks for the discussion, because you stressed a very important field, which are very important now in Latvia in defense sector. I think not only in Latvia, but also across the Europe and beyond the Europe. It's like very important, and it's thanks you very much that you stressed important things what we need to think into account when we are doing some improvements in our legislations. But I would like to do also some short wrap-up. I would like to thank you all who attended this conference in person and online. It was my pleasure to meet all of you here, because I see that you are experts, you are practitioners, you are NGO representatives, you are media representatives, and all of you are caring as a whistleblower, and I think that's the most important. And today we discussed the whistleblowing thing from very different angles. We discussed from the public institutions, media, from NGO. We discussed protection, mentioning that anonymity can be the main element into doing protection, but also we don't need to forget any other elements, for example, how the channel works, how the system is built, if there is trust to the system and communication towards society, explaining what means this whistleblowing. So we touched like very many different angles today. But the most important, I think, what we need to understand, like all of us need to understand, but I believe you are knowing it already, is that whistleblower is doing something for the public interest. He's doing something to safeguard our interests, and it means that we, I mean also public institutions, media, NGOs, like, we also need to do all what we can to ensure protection of the whistleblower. I mean all means, and not only these ones who was mentioned today during the conference, but also maybe we need to be more creative because yes, we need to save our whistleblowers. So I think it's the most important and the core element of the system should be the whistleblower. And what we need to do, we need to serve to the whistleblower. So thanks you for coming to this conference, and also to all participants who joined online, who joined in person. We will send you conference materials, so we will be in touch with you, and we are hoping for continuous cooperation, because this is something important we need to do.
No aizsardzības nozares. Es atnācu svarīgākā prezentācijas. Es arī tikai šo atnācu. Es ierakstīju savu darbu sarakstā. Jā, nē, man liekas īstībā jā, jo es godīgi, man tiešām es jūtos vainīgs, tiešām šausmīgs skrējiens, un es tā kā, es tiešām vakar apsēdos, es saprotu, un es iedziņos, un es tiešām, jā, es nekad īstībā nebiju, un es par šito jomu tieši tādā griezmā vispār domās, ka tā ir man īstībā arī personīgi, tāpēc es piekrītu, šitādā mazliet aizsardzības. Viņa tiešām Jūs arī nesat? Okay. Tik daudz jau, ka mēs jau tipos, Jā.
towards ourselves, but the public doesn't see it. Yes, it integrated, I think, but also the other colleagues. But also the questions, they're very interesting.
I don't know.
Are you on a link? Oh,